I'm Stephen F. Ferris, Esquire.
And I'm Jake I. Newsome, Esquire.
And welcome to the Reading is Fundamental podcast.
The podcast where we talk and break down legal issues in and related to the entertainment industry.
Why? Because we're attorneys.
And you're not.
Well, most likely you're not. We're creating this podcast with the goal of educating independent content creators who likely don't have access to legal counsel when confronted with complex legal issues.
But we welcome attorneys to listen in and learn more about emerging issues in entertainment law. And if you are an entertainment attorney yourself, feel free to give us some feedback and say something in the comments.
I have over a decade of entertainment experience working as porn performer Blue Bailey in the adult entertainment sphere. You may know me from such films as Suck Dick, Save the World 3, Butt Snack, Viral Loads, and my personal favorite, Ho Ho Ho, Blue Bailey's Christmas Breeding. I'm a California licensed attorney and founded the law office of Stephen F. Ferris with a focus on counseling queer content creators ranging from digital online platforms, adult performers, porn producers, drag entertainers, and local queer businesses. During my time in the industry, I've seen people get into a lot of trouble for simply not reading their contracts, understanding the terms of service, or not having access to legal services to figure out what the hell a contract means with all the complex legal jargon.
And I have a bit of a different background. I went to school to become a music teacher. I taught choir for a while. My whole kind of early childhood was in the choral realm, in the music industry, the classical music industry, but I ended up leaving that, going to law school, and now I work as a corporate law attorney. But I really want to kind of get back to my roots and to answer some of the questions that all of my musician friends have. So this is my way to get back into the entertainment industry and help my friends.
So pretty much, we're both fagged with entertainment backgrounds, and we could say that. If you're not a gay man, you can't say that. We met in law school, and in addition to bonding over grueling months studying for the bar exam, also bonded over our weekly Drag Race viewing rituals.
And like we said, we want this podcast to be a way for entertainers to understand what's going on as they approach their legal situations in their careers. And all of this is going to be done through the lens of our lives, our gayness, our sex positivity, our radical acceptance, and our love of Drag Race, which is why this podcast is named Reading is Fundamental, because you need to read your damn contracts.
Can I get a gay man?
Yes, gay man. But before we do that, we have to give you a little disclaimer.
The information on this podcast is for general information purposes only. Nothing in this podcast should be taken as legal of any individual case or situation. This information is not intended to create, and receipt or listening does not constitute an attorney-client relationship.
So what's today's topic? Today we're talking about the history of obscenity in the United States and how its varying interpretation over time and how its targeted prosecution has affected what Americans have access to in the media.
So what exactly is obscenity? Merriam-Webster defines obscenity as the state of being obscene, and obscene has multiple definitions. It means disgusting to the senses,
abhorrent to morality or virtue,
containing or being language regarded as taboo in political usage,
repulsive by reason of crass disregard of moral or ethical principles. This reminds me a lot of you.
Or so excessive as to be offensive, aka hella extra, which reminds me of you.
Oh. But as you can see, these are all subjective, and none of these are actually legal definitions about what constitutes obscenity. So why is understanding obscenity important?
Well, first of all, it's against the law. Federal law prohibits both the production of obscene matter with intent to sell or distribute, and engaging in the business of selling or transferring obscene matter using or affecting means or facility of interstate or foreign commerce, basically using the internet, using shipping, using the mail, any way to transport media from one person to another.
I want to give a shout out to the drag queen Obscenity. I don't know if you knew of the drag queen Obscenity.
I don't. Who is this?
She pronounced it Obscenity. She's a very famous Reba McEntire impersonator from the South and is great friends with Trinity the Tuck. So I think she deserves some recognition on this podcast.
So to sum it all up, it's illegal to sell and distribute obscene material on the internet and in the mail. Convicted offenders face fines and up to 5 years in prison.
Now, Stefan, I know you love a good prison scene, but...
And I do love prison butts.
But we need to get into the meat of the podcast, so let's take a commercial break and get into it when we come back.
And now, a word from our sponsors. And this is our first episode, so we don't have any sponsors yet. But if you would like to be on a sponsor on our podcast, Jake will tell you where you can reach us at.
Please reach out to readingisfundamentalpodcast@gmail.com. Again, that is readingisfundamentalpodcast@gmail.com. We're looking for anybody who's interested in entertainment law or shares our love of sex positivity, radical queerness, and drag race. Hit us up.
And if you have a fun idea of a topic for the podcast or something that you'd like to ask questions or know about, please feel free to hit us up.
And now, let's get back to the show.
Reading is fundamental.
So, we gave you a few examples of what the dictionary definition of obscenity is, but that's not the legal definition. In fact, the legal definition of obscenity has evolved over time through a number of Supreme Court cases.
Yep. The probably most prolific one, and I remember reading in law school, is Roth versus United States. Is a case in 1957. Roth operated a book-selling business in New York, and he was convicted of mailing what was considered obscene circulars and books in violation of the federal obscenity statute. Were these, what were the sexual influences of these? Do you know?
I don't, off the top of my head. I do know that obscenity cases were brought for women showing their ankles or for kisses lasting too long. It really could have been anything.
The ankle.
Yeah.
I'm guessing that these are probably a little bit more revealing than those.
Yeah, I would think for this case it was probably more what we consider traditional obscenity today, namely porn. This case was combined with a California case, Alberts versus California, where Alberts was convicted not under a federal statute, but under a California obscenity law, basically for selling the same thing, obscene books.
So the question that they were trying to answer here was, did either of these federal or California restrictions that prohibited the transfer of obscene materials through the mail, did that impinge upon the freedom of expression as guaranteed by the First Amendment? So this came as a First Amendment issue.
And in a 6-3 decision written by Justice William J. Brennan Jr., the court held that obscenity was not within the area of constitutionally protected speech or press. The court noted that the First Amendment was not intended to protect every utterance or form of expression, such as materials that were utterly without redeeming social importance. The court held that the test to determine obscenity was whether, to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interest. Now, do you know what prurient means, Jake?
I don't.
No, why don't we look it up real quick?
Okay.
The court held that such a definition of obscenity gave a fair warning and satisfied the demands of due process. Brennan would later reverse his position on this in Miller, California, which we'll get to in a couple minutes.
I do know Miller v. California. So, I mean, I guess the general rule that they came out with was, again, whether to the average person, so this includes everybody across the country, applying contemporary community standards, not the standards of the past, and the dominant theme of the material. So, you know, if there's just kind of like one small piece that happened in the material, it doesn't matter, appears to the prurient interest. So please educate me, give me some edification on what prurient means.
Girl, I asked you were supposed to look that up.
Oh, I was supposed to look it up. Sorry.
But since you didn't, I just looked it up. Prurient means having or encouraging an excessive interest in sexual matters.
Oh.
Now, excessive is very subjective. What is an excessive interest in sexual matters? A gay man's interest in sexual matters may be considered excessive to a straight man's. My interest in sexual matters may be excessive in comparison to Jake's interest in sexual matters.
Pretty much everybody.
And pretty much everybody. But I think another thing that's important to point out is that it's community standards. And this case was decided in 1957 before there was the internet. I mean, there was still television, there was still film, but really the community was where you lived. And a community in New York would be way different than a community in Las Vegas or Salt Lake City or somewhere in the South. So all of these community standards would be varying dependent on where you lived.
I mean, that kind of just leaves it kind of wide open, really, depending on where you live. It could be that, particular standard that you're living by. I mean, even culture between San Francisco and, LA is pretty different. We live here in the San Francisco Bay Area, and, we had the pleasure of going and seeing Miss Bianca Del Rio last evening in beautiful wine country. But, we noticed that there was a different crowd that was there. So maybe the people in that community would have a different community standard to, Stefan walking around with a jockstrap today.
Right. And then she mentioned that she was also touring in Texas and Florida, which would also have different standards of what is acceptable and what is not.
I mean, now that we think about it, Bianca Del Rio is probably going to get prosecuted for obscenity.
No, she's not. You're being ridiculous. But really, the rule that we got out of Roth was that obscenity is not protected speech. It does define and start to define what obscenity is, but the definition is so vague that there really is nothing to really work with at this point. For example, and this kind of takes us into our next case, a film being shown in San Francisco would be judged by different standards than a film shown in, say, Cleveland Heights, Ohio, which is where we find our next case, Jacobellis versus Ohio, which was decided by the Supreme Court in 1964.
So Jacobellis managed the Heights Art Theater in Cleveland Heights, Ohio. He was originally charged with 2 counts of possessing and exhibiting an obscene film, which was under Ohio law, and they convicted him and ordered him to pay a fine totaling about $2,500, which is about $22,000 today. I want to know, Stefan, which one of the films was he exhibiting? Was it your very famous butt snack? Was it Save the World 3? Was it Ho Ho Ho, Blue Bailey's Christmas Breeding?
Unfortunately, it was not any of those movies. The film was a French film called The Lovers, directed by Louis Malle. I may be getting that wrong. And is described as saddled with a dull husband and a foolish lover. A woman has an affair with a stranger.
Ooh.
A stranger, Jake.
Oh my God, she had a hookup.
I'm clutching my pearls right now.
It's a regular Tuesday for
I've
me.
never had sex with a stranger.
Today.
Anyways, yeah, today. Well, I mean, the day's not over
The day's
yet.
still young.
But this film, which basically included a one-time hookup, was charged, and if the fines were not paid, Jacobellis, who exhibited the film, would be incarcerated. He appealed to the Ohio Appeals Court, and then to the Ohio Supreme. Both courts upheld the conviction. The Supreme Court reversed the decision, but there was no consensus on what really defined obscenity or what to be looking for.
So this is one of the cases that we learn about in law school where there's a plurality decision, or where different justices write different opinions and agree to them, right?
And what happens in a plurality decision, Jake?
There's a plural of a decision.
And what does that mean?
It means that there's really no one answer to what it is. So if we have, 9 justices on the Supreme Court and 5 of them decide one way and 4 of them, go with the other decision, the majority wins. But a lot of the time, it ends up sometimes with a 3-3-3 split, or 2-5 to whatever the other math is. So in this case, we had that. There was a breakup between what Justice Hugo Black and William Douglas felt. They were under the camp that thought that the First Amendment did not permit any censorship of any kind. And that was different to what the Chief Justice at the time, Earl Warren, in his dissent, saying that the decision should be upheld under further state's interest, that the state should have their own ability to decide what is obscene and isn't. And then there was the final decision of Justice Potter Stewart, who kind of set the standard, I guess, for what we know of obscenity now. He stated that the Constitution protected all obscenity except for, quote, hardcore pornography. He wrote, quote, "I shall not today attempt further to define the kinds of material I understand to be embraced within the shorthand description, and perhaps I could never succeed in intelligibly doing so, but I know it when I see it. And the motion picture involved in this case is not that.
Which basically means that the Supreme Court was sitting up there viewing porn and viewing videos to figure it out what was obscene when they saw it.
Isn't that wonderful?
I know. Could you imagine Amy Coney Barrett or whatever the fuck her name is sitting there just watching videos trying to determine whether it was obscene or not?
I think Justice Kavanaugh might cry.
So the famous "I know it when I see it" decision of Jacobellis versus Ohio came in 1964, and our next significant case came 5 years later with Stanley versus Virginia. Law enforcement officers, under the authority of a warrant, searched Stanley's home pursuant to an investigation of alleged bookmaking activities. And during the search, the officers found 3 reels of 8mm film. The officers viewed the films, and I'm pretty sure that must have been a fun time, concluded that they were obscene and seized them. Stanley was then tried and convicted under a Georgia law prohibiting the possession of obscene materials.
I mean, that tells you what they did with it right then. They seized it. I'm sure they were having some popcorn parties.
Right. I wonder if they watched it at Stanley's house with him or took it home and watched it. Where exactly did they watch the films?
I'm thinking the precinct.
The precinct?
Yeah.
Ooh, precinct party.
Yes.
So the question in this case was, did the Georgia obscenity statute infringe upon the freedom of expression protected by the First Amendment? And this question is slightly different because we aren't in a situation where obscenity is being exhibited or transferred through the mail or over state lines. This is obscenity that's happening in someone's home.
So the court held that the First and 14th Amendments of the Constitution prohibited making private possessions of obscene materials a crime. So you can have possession of obscene materials and it cannot be a crime. So in his majority opinion, Justin Marshall noted that the rights to receive information and to personal privacy were fundamental to a free society. Marshall found that, quote, if the First Amendment means anything, it means that the state has no business telling a man sitting alone in his house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds. The court distinguished this between the mere private possession of obscene materials and the production and distribution of such materials. The latter, the court held, could be regulated by the states.
And keep in mind, this only applies to obscene materials, likely regarding adults of age. Obscene materials or child porn is regulated through other statutes. It would not fall within the definition of obscenity for the purposes of what we're looking at today.
So let me get this, get this distinction. Okay. All right, so let me get this distinction. They're saying private possession of obscene materials, A-okay, but right. You can't distribute such materials.
Right. So it's kind of like, in a sense, how drugs were decriminalized. You could possess them, you could have them in your home, but purchasing them or obtaining them or participating in them outside of the house is not kosher.
So our last case is Miller v. California. It establishes a 3-pronged test for defining what obscenity is. So, we had the amorphous, I know it when I see it. Now Miller is coming out from the Supreme Court and saying, here is a 3-pronged test that we can use to think or to see what obscenity is. So
it sets more concrete criteria for defining what obscenity is and takes it out of the abstract of what we've been dealing with, I know it when I see it, into pretty much a checklist.
Yeah. So, getting into the facts of the case here, Miller, after conducting a mass mailing, so we have another mailing here, he did a mass mailing campaign to advertise the sale of adult material. He was convicted of violating a California statute prohibiting the distribution of obscene material. And some unwilling recipients of Miller's brochures complained to the police, initiating the legal proceedings. I think I remember reading this in law school.
Oh, we definitely read this in law school.
Oh,
This is
yeah.
like the penultimate like obscenity case, and has set the standard for what obscenity is today.
I do remember because mail-in catalogs, and you could order like a DVD if you want, or not. God, not a DVD. This is 1973. You could order, I guess. Did they have VHS?
I don't know.
Okay, well, you could
Did
order
they have?
something through the mail. I do remember there being a catalog, and then that's why it was sent to unwilling recipients, because it was kind of just like a mail order thing, I guess, like a Sears catalog for your adult material.
Right.
But, people were pissed that they got it in their mailbox. Not all of us would be pissed, but I guess some people
I
were.
certainly wouldn't be pissed if someone sent me like some poppers
Ooh.
in a VHS. So I'm gonna need to clean the VHS at some point.
It sounds like a great day.
So the question in this case is: does the sale and distribution of obscene materials by the mail protect under the First Amendment again? And which is kind of like the reoccurring question that we've had. It's really just defining what obscene means. And in a 5-4 decision, the court held that obscene materials did not enjoy First Amendment protection. However, the court modified the test set out in Roth, the I know it when I see it, holding that the basic guidelines for the trier of fact, the court, must be whether the average person applying contemporary community standards would find that the work taken as a whole applies to the purient interest. We've seen that before. Mm-hmm. Whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, and, which means all three of these need to be made, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value, which is known as the SLAPS test. And the court rejected the previous decision that the work must be simply utterly without redeeming social value.
Okay, I do remember this case specifically because of the SLAP test.
Yes.
So this whole lacks serious literary, artistic, political, or scientific value. I was like, who is the court to decide what is artistic? Like, why do they get to decide what it is? So okay.
Right. I mean, and but I mean, this does kind of in essence take most adult films out of the realm and definition of obscenity. Anything with a plot has like artistic value, and it kind of elevates it from mere images to a story or artistic or literary value.
Yeah.
I would even argue that gay sex in and of itself videographed is a political statement in
Agreed.
comparison to the rest. I don't know if the Supreme Court would accept that definition.
So now that we know the factors to go through, just a reminder, standards taken as a whole, appear to the purient interest was the first one.
That's sexual interest.
Oh, sorry. Yeah, sexual interest. 2, whether the work depicts or describes in a patently offensive way sexual conduct. And 3, whether it's taken as a whole, lacks artistic, literary, political, scientific value. I mean, can we use one of your wonderful films as an example and see if this passes the test?
Sure. I mean, pretty much any film where I'm giving a script or dialogue or there's a story, in essence, takes the work from being quote unquote obscene into having some sort of redeeming value to it. And I know that that's not the test exactly anymore, but just adding some element beyond just the depiction of the sex and the ejaculation and all that moves it out of the realm of obscenity. And like we mentioned earlier, I would even argue that certain queer acts of sexual expression are political in and of themselves. Certain acts of gender expression are political in and of itself. So there seems to be broad discretion over what would hit the SLAPS test to elevate the work from quote unquote obscenity into something more.
Yeah. I mean, that's an interesting question to think about, because it's like, all right, if your line was, we need a script, we need lines, we need kind of a story, costuming can do that, and then bring like some kind of literary artistic element to it. I mean, what if it's just an OnlyFans porn or, something that somebody set up with their camera or something like that? that's probably not having the literary, artistic, and political. But as we had mentioned, we need all three of these to be considered obscenity. We need the first test, the second one, and the third to be taken together to have obscenity. And I think it's interesting that the second factor is, in a patently offensive way. So it's like, again, what is patently offensive? It needs to be like...
Is that like patent leather boots?
Ooh, patently... I love that. But it's like, what is patently offensive? And then, some people engage in acts for the purpose of being offensive. Like, we go to drag shows here in SF, and there's some pretty, shocking and obscene things that happen sometimes on stage. It's meant to be jarring and, offensive and to make you think about norms and things like that. So, it's another way, it seems like, to bring a person's personal taste into it, even though they're trying to make it an objective standard.
So doing just a quick Google search, patently offensive means so offensive on its face as to affront community standards of decency. Another definition is, which goes substantially beyond customary limits of candor in describing or representing such manners. It also means obviously and clearly disagreeable, objectionable, repugnant, displeasing, distasteful, or obnoxious to contemporary standards of decency and propriety within the community standards. So I would even argue that prong 2 is in direct conflict of prong 3, based on how Jake kind of pointed out that the point of art is to cause emotion, and sometimes art is in and of itself patently offensive. It's made to be displeasing, distasteful, and obnoxious to contemporary community standards because it has a message.
Yeah. All art doesn't have to make you feel pretty and have butterflies and all the things. Sometimes art is meant to feel some kind of emotion that's deep and raw and might be hurtful sometimes. Sometimes it makes you squirm. I'm a big fan of the Dragula series. And, at the end of every Dragula episode, there's an extermination. They make them get tattoos or jump out of planes or things that really scare them in order to kind of shock. So I think it's art. I think that it does kind of contradict what they're saying as the third prong with the slaps test.
And I'm just a big fan of squirming.
All right. So before we wrap up with our discussion, we want to do a small segment where we're talking about something in entertainment news, something that's come up pretty recently, and kind of just give our thoughts about it. We're going to trade off every week. So my thing that I wanted to talk to you this week about, Stefan.
And I don't know any of this. Jake has picked something randomly to tell me about, to educate me on, and next week I get to fuck with him and do the same.
Oh,
so go for it. What are we discussing that I'm supposed to sound intelligent about today?
I want to talk about the Scarlett Johansson settlement with Disney, because I thought it would be a good just topic, because we both love Marvel, we both love going to superhero movies.
We both saw Black Widow
We
together.
both saw Black Widow and Shang-Chi. But, as you probably know, a couple months ago, Scarlett Johansson brought a lawsuit against Disney because she lost profits with this kind of dual streaming and theatrical release of Black Widow. So, of course...
Which, in my defense, I bought it on Disney Plus and I saw it in theater. Not that it was that good. I just forgot that I bought it on Disney Plus.
You gave her coin.
Yes.
What she would have gotten. But, the reason that she did it... I should say the reason that Disney released it both in... streaming and theaters is because, the pandemic is happening and we can't go to theaters and, all the states, and there's different patchworks of, who's open, who's not. So they just released them both at the same time. I honestly don't blame them for doing that. They're trying to bring things forward, and they're trying to, make sure that there's still entertainment going and the buzz is still happening. So I don't blame them for doing that. But Scarlett Johansson was a little mad because she lost, literally millions of dollars that she would have gotten from box office tickets. The thing that I think is most interesting in this, I couldn't find, the actual complaint, but I'm assuming that Somewhere in Scarlett Johansson's contract is an explanation of how she would get paid through these theatrical releases. And it's going to say, she gets X% of the box office totals. So, of course, if it's a flop and if it's a bad movie, her cut's going to be bad. But she's Scarlett Johansson. She knows that she's an Avenger. This is going to be a big thing.
She was an Avenger.
Oh, I'm sorry. She was an Avenger.
She died.
Oh.
Spoiler alert.
In which one? And
No, she died in the Avengers. Yeah.
Oh.
The Avengers movie. Hello.
I totally remember that.
Okay, it's your segment. Go on.
She was an Avenger, so she's gonna make a lot of money off of it. So she puts a lot of stock into the fact that it's gonna be a big box office release. She might even take less of a base pay for it, and then more of the kind of ticket sales afterward, because it's better for her. She's gonna make more money even with a couple more percentage points of it. So basically, she's losing out on all the money she would have made at the theatrical release, and she's not making any money with the streaming release. She's going to make a certain percentage off of each of these releases. Maybe she even has DVDs in it or downloads or something like that, but there was nothing in her contract that said streaming, which is kind of hard to say, because when at the time she was signing this contract, let's say it was 3 years ago before the film was doing it. I mean, Disney Plus hadn't even come out yet.
Right. I mean, she could have signed this deal years ago, before she even starred in any of these movies, to have her do the first. I'm a horrible Marvel fan sometimes. Whatever movie she first popped up in could have had 4 movies tacked onto it.
Yeah. Next Iron Man 87.
Yeah.
To go with it. But she could have signed the contract a long time ago. Disney Plus probably wasn't a thing. Obviously, we're not going to be predicting what the pandemic or that the pandemic was going to happen or anything like that. So it's not in her fault to say I'm going to bank on the theatrical releases, because she acted to the best of her knowledge. I think my biggest takeaway from this is to definitely, ask your attorneys that when you're working with these deals to kind of think about the unknown as much as possible. In my job every day, I'm always what's the worst thing that can happen? And then, kind of build my risk management off of what that is. This is not what the worst thing is can happen, but it's thinking of all the possibilities that might happen. And, there could be a way to capture this in the contract by saying, an other available media or something like that, where, you're going to get, 5% of the cut from any other available media that we have in the future. It could be, airplanes, it could be spaceships, whatever it is. You have that kind of catch-all phrase for it.
So I did follow the lawsuit a little bit when it first came out, and my understanding was that should ticket sales in theaters reach a certain threshold, Scarlett would get a bonus or additional payments, which would encourage her to go on tour and promote the movie and to say nice things about the movie. And pretty much when Disney decided to do a dual release of the movie, where people could watch it on Disney Plus, ticket sales dropped. And Scarlett basically was I'm doing what I needed to do promoting this movie, but you didn't give me the opportunity to succeed by giving it a theatrical release. Which is a pretty novel concept, because we didn't really have dual releases before COVID.
Yeah.
That may have been a plan that Disney had in the future, but was certainly expedited to kind of meet the needs of what was going on right now. And I guess my kind of takeaway from this is when I first thought that she sued Disney, I thought oh, she's no longer an Avenger. She doesn't need to work with them. She's digging her grave. And then we just read in the last week or two that a settlement came out and that she's in talks for a new Disney project.
Yeah, Tower of Terror, right?
Yeah, Tower of Terror. And it's, to me, I think the takeaway is one, read your contract, know your obligations, and definitely stand up for yourself. When Scarlett announced her lawsuit, Emma Stone did it. Some dude from the Jungle Cruise did it, and it kind of started a movement where people stood up to the studios. And it's also just because your contract says something and the other party is in breach, you don't necessarily have to be an asshole about it. Like, we didn't see Scarlett out there dragging Disney or causing drama or like saying shit. Like, she filed her lawsuit, which she should have done. They were in breach. But it seems to me that she still maintained relations to keep an ongoing business relationship.
Yeah.
Just because someone breaches your contract doesn't give you the right to kind of go sour, you know? I mean, maybe it does, maybe it doesn't.
So I'll stop you there because I don't think that the claim was for a breach of contract. I think it was, something outside of it, like bad faith.
Gotcha. Okay.
So I don't think there was anything in the contract that they, said they were going to do that they didn't do. It's that they came to the table in bad faith, that they didn't disclose to Scarlett that they were going to do this double release or that it was even anticipated. So she didn't, even think to like, think about the fact that this might happen and negotiate to her favor.
So for our listeners who don't understand what good faith is, what does that mean?
Oh, yeah. I mean, just being a bad actor, kind of like withholding information or not, being completely upfront with it, like deceitful or anything like that. It doesn't have to be that, Malicious, yeah. But if you're not presenting all the information as necessary to make an educated decision about what you're signing, then, I mean, that could be bad faith. You need to make sure that you're entering this, that you're actually of the same mind when you're entering these contracts, so that these kind of bad faith claims don't come up.
So in essence, like, Disney may have not had any obligation in their contract to not release on Disney Plus at the same time.
Yeah.
But you're saying that Disney should have included Scarlett in the conversation that was happening, and that there should have been an effort to, if she had duties to perform, to increase ticket sales, and that was no longer the plan on Disney's end, they kind of should have let her in and helped develop a new plan that would have worked with a different bonus structure.
Yeah, I think they should have, I mean, I don't know how much they can disclose, but like, if they were able to say, hey, we actually have this like streaming platform that's going to be launching in a couple of years. We might be putting it on there. So it's like, letting her know that there's a possibility that this movie might be on another platform. Again, I don't know how much they can disclose ahead of time to be able to do that. Or, like you said, we're in the middle of a pandemic. Everything is changing. Everything is weird and different. They could come to her and be like, hey, we actually have a change of plans. Like, we're going to be doing this and this. Can we renegotiate what we had said before? She was obviously pretty upset because she's blindsided probably that this happened. But yeah, so they ended up settling. I wanted to share at least why I think they settled. One, because the cost of litigation. Like, it's going to go on forever, and, it costs millions of dollars to litigate these things. And two, I think they both kind of have good arguments either way, right? Like, they could have really said, Scarlett Johansson, you really should have been advocating for yourself and blah, 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 blah. And she could really say, I didn't know this information. Like, there's no way I could have negotiated if I didn't have this information. So I think they both have good arguments. It would be litigated to hell. And so it'd be, lots of money to go along with it and lots of time. So just not worth the effort. And I think two, I think the success of Shang-Chi releasing and being, I think it was one of the box office records, it's like they released it in theaters. It was amazing. So it kind of bumps up Scarlett Johansson to say like, hey, he made a lot of money because of this. Right. If we would have done a theatrical release, it would have been this much. So I think they kind of saw that and were like, we're going to settle, because I think it was only like 2 or 3 months in between the time. So it was a pretty quick settlement.
This also like is something to keep an eye on. Like, we're not out of the woods COVID wise.
Yeah. And
Disney has started switching to theatrical releases only, and I'm certainly starting to see movies as theatrical release only. But we have yet to hear from other studios. I know pretty much all of the Warner Brother movies for 2021 are going to be released in theaters and on the streaming platform, and I'm not quite sure whether there's been a decision for 2022.
Yeah.
So this issue with the contracts, it may not have been litigated, and there may not be like legal like court precedent, but it does start to reframe industry precedent on how we're going to see big celebrity entertainment contracts negotiated if there's the possibility of things going directly to the streaming service or a hybrid of theatrical release and streaming service.
Yep. So, I mean, look out. This is kind of like the beginning of the frontier, maybe, like of what these changes are going to be. The pandemic changed a lot of things for a lot of people, and it's changing how the entertainment industry works too. All right, so we love Scarlett Johansson, but let's get back into our topic of obscenity. We're going to kind of wrap up and summarize it by asking ourselves some questions like, what do we think they got wrong? What do we think they got right? Where are we now with this obscenity discussion?
Sure. I mean, I would probably be one of the Supreme Court justices that would want to sit there watching porn all day. So
Perks of the job.
I kind of like I know it when I see it. As a content creator and producer myself, those standards were too vague to know how to operate. If you don't know what obscenity is, then you don't know if what you're making is obscenity. So I think having the Miller test that clearly defines and three prongs what you're looking out for, and kind of having SLAPS protection, which was the serious, literally artistic, political value,
or
scientific value. I think having that and knowing that that's kind of your get out of jail free card is good to know. In general, I don't think there should be any obscenity law so long as the people in the video are of age and consenting.
Well, I mean, I'll jump in and say like that was something I thought about as we were going through this. You know, I was kind of thinking about like, what do I like? What do I don't like about it as we were going through? But then I stopped and thought like, do we need an obscenity regulation? Like, do we need to be policing this? Like, what is the societal benefit of policing obscenity? And, you know, I do agree that we have a better guidepost under Miller to, you know, have this three-pronged test, but I think there's still things that I would change in it. I understand, you know, it starts out with the average person. I get that because, you know, we can't be legislating for a fringe one way or a fringe another way.
Right.
You know, it kind of needs to be like as much down the middle as we can. And, you know, again, contemporary community standards is hard because it's like, where are we? And then the second prong we discuss is like, what is patently offensive, and does that abut against, you know, somebody's right to produce their art, as shocking as it might be? Maybe we just get rid of this. Like, maybe we get rid of the second prong and like, it doesn't matter if it's patently offensive because it shouldn't. Like, I'm sorry that you're offended.
I mean, in a sense, I could see that if the content is broadcast or displayed in public where people are kind of a captive audience, which means that they're kind of forced to watch it and they don't consent to it. If the consent element's not there in public, I could see an obscenity law existing. Mm-hmm. But for viewings where you need to pay a ticket or go to a place or watch it at home or go to a website, or even if it's like on television, like, don't watch it. Don't be Valerie Cherish. I didn't need to see that.
I didn't need to see that. So maybe, I guess what you're saying, or what I was kind of getting to and you finished, is that like, maybe we don't need to be thinking about the content itself, but the person's consent to being like shown what this content is. Like,
I mean, and even that is tenuous for me. Like, I'm of the school of thought to have as much freedom of expression as possible, and it shouldn't be on society to censor themselves to the lowest common denominator. Like, if you can't handle something, then don't do it and look out for yourself. It would be, to me, like going into a bar and being like, this alcohol is triggering. I can't handle seeing it there. And what about other people that are going to be triggered? Like, we just shouldn't have that. And really, like, maybe they shouldn't be there. Maybe they should go somewhere else.
Now I'm getting like, I don't know, flashbacks about cases that were like you are subject to what the world is as you exit your home. You know what I mean? It's
Right.
like you can't expect that the world is going to be what you want it to be or what you expect it to be. Sometimes there's bad things in the world, and if you don't want to see them, it's like, well, then don't go outside.
Right. I mean, and to some people, me going out holding my partner's hand is offensive.
Yep.
And to me going out and seeing people speak hateful religious things is offensive. But do I think that they should be prohibited from doing that on both sides? No.
Yeah.
Like, both things need to exist. And I think society, in essence, is even better to being exposed to these ideas that are offensive.
Yeah.
Kind of like, I believe it's like infection theory. Like, if you go out and you're not exposed to harmful or offensive ideas, then your body or your mind is going to break down the second you are.
Yeah, yeah.
And it's not necessarily feeling like you should be subjected to them all the time, or like I don't know, like tortured by them, but like just merely encountering something in public.
I agree too. You just because you don't like it doesn't mean it has to go away. Right now we're talking about, obscenity as it relates to, sexual content, but I mean, it permeates in every other way too. It's like, just because you don't like a person's religion, color, race, creed, sexual orientation, whatever, doesn't mean that they should go away either. So, well, I've definitely enjoyed our first conversation here.
It was all right for me.
Oh, wow. Okay. Today we learned about adult content being regulated by obscenity statutes, and next week we're going to be discussing how the adult entertainment industry is being regulated under sex trafficking statutes, namely SESTA and FOSTA. I'm very excited to have this conversation with you, Stefan, because I know that this is something that you know a ton about. You've written, you've gotten published in it, so I know that you know a lot about it, and I'm excited to learn from you.
And I'm excited to chat with you about it. And I think maybe a lot of our listeners may not know about FOSTA SESTA specifically, but they've certainly encountered it in their lives, whether that be not having access to Craigslist personals anymore, or certain words in their Grindr or Scruff profiles being like automatically filtered out. And I'm excited to break it down with you in next week's episode.
Awesome.
And our first two podcasts are intended to prepare you for our first YouTube podcast hybrid coming out later this year. That's going to be breaking down the MasterCard crackdown on fan sites such as OnlyFans or the queer-friendly Just for Fans, including new responsibilities put on by the financial institutions, new record-keeping requirements for the content creators, and pretty much new roadblocks that adult entertainment content creators are facing in the age of SESTA FOSTA.
Thank you so much for listening to our first podcast. Let us know what you'd like to hear. Write us in at readingisfundamentalpodcast@gmail.com, and make sure to follow your favorite gay attorneys at Blue Bailey XXX and at Darkly Dreaming Dextra.
You can find Reading is Fundamental everywhere podcasts stream, and on Instagram, Twitter, and YouTube. Because reading is what?
Necessary to understanding the terms, conditions, expectations, and obligations of your entertainment contracts.
See you next time.
Bye.
Fundamental.